I'm not sure what he's confused about, quite frankly. Nothing from the people.
I was confused about the number. Like when I got the number, I didn't get that. Well, I never got the number. I got the Zoom link and I got like a number for court. I never got the actual probation number when I tried to. Now she just actually gave me the probation number. I got it saved in my phone now. Before I just had the court number and the day I was supposed to come to court, which is today.
Bench warrant to issue. No bond. So you need to turn yourself into the Washington County Jail. I give out the phone number each and every time to everybody, and I ask them if they have it. So I'll see you.
Okay.
State of Michigan versus Eric Martin, case number 23S00425.
Rachel McDuffie for the people.
Assistant Public Defender Sandra White on behalf of Eric Martin.
Mr. Martin, please unmute. State your name for the record.
Can you hear me?
Yes, sir. Please turn on your screen also.
What's going on? Hold on, I'm trying to do that here. I'm not seeing it. Okay, there we go.
There you go, sir.
This is Eric, capital E, lowercase R-I-C, capital M, lowercase A-R-T-I-N, living man, hereby threatened arrest, and appearing by special appearance under general jurisdiction.
Thank you, sir. This matter is scheduled for a pretrial today. I received a letter from Mr. Martin that was forwarded to the prosecutor's office indicating that he was not able to open the discovery that was provided to him, and requesting that he get another copy so that he could try to get it to work. He indicated that he had tried to go to the library in order to get it to work with no success also. And since that time, Ms. McDuffie, were you able to provide him with another copy?
No, Your Honor, we have not provided another copy. So the issue, I think, is that Mr. Martin, first of all, let me just confirm that when discovery was demanded and ordered at the October 26th final settlement conference, obviously he received it. He picked that up on November 7th. That contained a flash drive with the media, which is MSP WatchGuard video, a copy of the police report, and a copy of the citation itself. So Mr. Martin has received everything that we would provide to any other attorney, except that it's not a link because he didn't give us an email and he wanted it mailed to him. But what often happens is that to be able to view that, you need to possibly install a player on your local computer so that you can, play that video. And if Mr. Martin is going to the library, it's most likely a system that's not going to allow him those types of permissions to do that. So I would encourage that we don't really have, it's not an issue, I don't believe, with what he was sent having some sort of error on it, but I think that he should connect with his standby counsel because the PD's office would likely be able to assist him in viewing that.
Thank you, Mr. Martin. So what she's saying is you have to install a particular application called a player to be able to play that. It's not going to just play on its own. You have to have the downloaded app or whatever it is that you need to play it from that. Download it to your actual computer. When I was a defense attorney, the way we had to do it is to download that player as well. That's the way the process works, sir.
So I don't know. I don't understand how to do that. So, and I object to her saying it's not nothing they sent. It shouldn't be this complicated. It should just be able to review it.
Well, that's how it works for everybody, you and every other attorney, sir. So what she's suggesting that you do is to get with Ms. White, who is your standby counsel, and have her assist you with downloading that so you can review it, sir.
Well, as I objected to before, I don't accept no attorneys because then that would give unlawful, fraudulent presumptions, and I'm a defendant, and along with a lot of other presumptions, which I'm going to be sending Affidavit to rebut 12 of the general fraudulent presumptions that's done in cases. Haven't did it yet, but yeah, that's the problem with that.
Well, that is your choice, but that is the mechanism for you to review it. You can utilize what is available to you or you cannot, but those are your choices. I'm gonna give you one more chance to figure out how to get that done. If it's not done at the next pretrial, then we'll just keep moving forward. Okay?
Well, no, I object to it. Well, you know, I need to be
That is
able to.
fine. You can object to whatever you want to object to, sir, but that is what we're doing today. Pretrial in this particular matter is going to be adjourned to February 1st, 2024 at 9:00 a.m. We will see you then.
Hold on, let me write this down. So February 1st,
Correct?
at what time?
At 9:00 a.m.
9:00 a.m. Okay, now this lady you're talking about, what is her name again? I don't have her number or nothing.
Miss
Sandra, I'm sorry,
there you go.
Sandra White. It's on the screen there. Can you see it?
Yeah, I see the name, but I don't see no number or nothing. And
Okay, will you answer our calls? I'm gonna give you the phone number. You ready? I'm
yeah,
gonna give you my office number, 734
yeah,
545
yeah.
3486.
3486. All right.
Okay,
I just wanted to Washington object again to her representing me because, like I said, I'm always of the position to present myself as a living man, so I'm not going to give up my right to do that. But but I will contact her if you guys are going to force me, so to say. It's only going to be it's by force, and not give me no other option to review the video myself due to them not sending something that can be reviewed. But that's all I got to say on that. Like I said, it'll be by force. It's not you know, they're not giving me no other option. So
And just like that, the hearing ends with one of the most brutal courtroom reality checks imaginable. After all the objections, all the sovereign citizen phrases, and all the attempts to resist help, the final truth becomes painfully obvious. The defendant still needs assistance just to access the evidence in his own case. That's the irony here. He repeatedly insists he can represent himself perfectly well, while simultaneously struggling with the most basic parts of the legal process and modern technology. And the judge? Completely unfazed. Throughout the hearing, the court stayed focused on procedure, offered practical solutions, and gave the defendant multiple opportunities to move forward productively. But instead of taking those opportunities, he turned a simple technical issue into a full courtroom spectacle. Now I want to hear from you. Should courts continue being patient with sovereign citizen-style arguments, or should judges shut them down immediately? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.